Hey y'all, it's Pam Esquire, also known as your law intellect. You guys excuse this, I just got off the road. You guys know it's my birthday weekend. My birthday is in approximately an hour. And I had to jump on here and talk to you guys about one of our favorite people, right? How's everybody doing? Thank you so much, Ben Childs, for the gift that you gave. I really, really, really appreciate it. It was very generous and nice of you. I have to shout you out. So we'll make you the sponsor of this show because you definitely paid for it. No, I appreciate it. I appreciate it. Hey, Ray Bishop, Linda Gibbs, Alice, Davita. I know it's late. I know it's late. Shelly, Jackie, Queen. Hey to all of you guys. Tay Tay, Faith Speaks Life. Course, St. James. My mods are in the house. Jeff James. Thank you so much. Thank you. Y'all, I'm a probably tomorrow. Well, that's what I was told anyway, that we'll hop on maybe sometime in the evening and we'll chit chat because I got to spend my birthday with you guys. So I'm going to try to get through a couple of documents. I had a couple of people that were inboxing me or emailing me about there was an article that came out with Whitehead regarding the feds trying to get into the devices. They didn't say what type of devices there were. I'm assuming they're computers, things of that nature. And they asked for the passwords, and Whitehead said no. So the reason why I had the document already, and what the New York, I don't even remember which paper it was. But the reason why I'm not going to read the paper, I'm just going to do it directly from the document, is because it's clear. The only reason why they're talking about Whitehead is because they don't like Mayor Adams. And they get a little embellishing, and we don't embellish. We don't have to embellish in this situation. So I'm just going to show you guys the document so you guys know where it came from. The Daily News. Okay. They all you got the New Yorker, you got the New York Times, you got the Daily News, you have, is it New York Mag? It's been a whole lot of exposés on him. So, but I'm trying to get right into it because once, as you see, I am in a room, and once everybody gets in here, then I won't have any quiet at all. So this is the document that the whole conversation originated with. So what happened, if you guys recall, if you guys follow, which most of you guys do, if you look at the previous videos, I said that there were a lot of motions filed. One of the motions that Whitehead was asking about was to make sure that he received all of the discovery. The judge also orders that you meet and confer, and the reason is so you can come up with dates that are comparable to both sides for discovery, deadlines, motions, things of that nature. Apparently, the government came with dates and deadlines, and Whitehead's attorney didn't agree with those dates and deadlines. So there were some things that they were able to come to an agreement on, and some that they weren't. So this is called the joint pretrial order that they came up with. So as you see, it says the parties. Oh, before I get to this letter, so this is a letter to the judge about what they met and conferred about. But there's something called Brady, and it's from a court case. And we may have talked about this before. When you talk about Brady material, that means that, say, for instance, the government gets any type of material that is pro Whitehead, that is good for him, good on his side, helpful to him. They have to turn that over too. They can't just turn over all the bad evidence. They have to turn over the good evidence that are beneficial or that support him in his defense. And so if you don't turn it over, then it's called a Brady violations. There have been cases that have been dismissed. They've had people that's been let free from prison, all because of Brady violations, because they were withheld. So What his attorney was doing was trying to consistently ask to make sure, are you saying that we have all the Brady material? The thing about the feds, and this is what I learned when I did a federal criminal case, they do not just turn over everything just off jump. You're gonna get it in increments, and sometimes you get things like wiretaps almost right before you go to trial. They just have to turn it over. They're trying to, they being Whitehead and his team, looks like, well, it's his other attorney, one attorney that's filing all these motions, is asking for this Brady material. So they've been having spats, I guess, about, well, I don't want to say spats, but they've been having disagreements about the dates. So this is the pretrial, basically the pretrial order. So we're talking about discovery, which is all the evidence that the prosecutor has. So it says the government has represented to the defense that it has complied with its disclosure obligations pursuant to Rule 16 and Brady. The government has represented to the defense that it has completed its production of Rule 16 material with the exception. So they're saying they turned over all of the material that they had, even Brady material, with the exception that 13 of the 15 electronic devices seized pursuant to a court authorized search warrant awaits extraction. 2 of the 15 have been successfully extracted, and those extractions have been made available to the defense. So we saw in the indictment that there were 2 cell phones. So I'm assuming that they were able to extract out of the cell phones. The government is informed that the software necessary to access the data on these 13 devices will be available this quarter. One of these 13 devices is open, meaning its content can be viewed on the device, but it cannot yet be extracted. The government has offered to make that device available for review on site for defense counsel. So there's one that they can look at, but they haven't been able to take the materials out of to put it in paper form, but they offer the defense to go down there and to view the evidence. So they can't say that they were somehow, we're not a surprise litigation tactic type of a country. So like when you watch Matlock and it's like the surprise witness just pops up, that doesn't really happen in real life. Well, it's not supposed to. You're supposed to, whatever witnesses, whatever evidence, you're supposed to be made available to the other side. So they're offering for them to come over and to look at that information. So it says the government has offered to make that device available for review on site by defense counsel. The defense and the government have also discussed whether the defendant wishes to provide the passwords necessary for the government to access these 13 devices, which, if provided, would allow for their immediate extraction. Defendant does not intend to provide these passwords. So that's where they got that from. The defense informed the government that it disputes whether the government has complied with Rule 16 obligations, including disclosure of Brady material pursuant to docket number 5. So they're saying the defense disputes and thinks that there's more evidence that should be considered Brady material that perhaps has not been turned over. The defense intends to file a motion on this regard on or before March 15th, which the court previously set for pretrial motions. The defense has declined to agree to the government's request to a date certain by which to file the motion and agreed upon dates for filing of any opposition and reply. Okay. It is the defense's position that they may file pretrial motions and at any time before March 15th. So they can't even agree on when motions should be filed. This is usually like so basic. Like you literally sit down with the government and you just come up with dates that you think are feasible. Like if I know I'm going to file 5 motions, motions to suppress or whatever motions, then I just, we just come up with dates to make sure that it happens. Because you rather you do it than the court do just pick dates, and then you got vacations and bar mitzvahs and birthdays. I mean, and so anyways, if the defense position that they may file pretrial motions and at any time before March 15th, pursuant to the court order on December 22nd, and that the government is then required to file a response to each motion within 14 days, and defendant may file any reply by defendant within 7 days thereafter per local rule 49.1. And then they talk about bill of particulars. Following the parties meet and confer, the defense filed an amended motion for a bill of particulars, and the governor intends to file a response on or before February 13th, 2023, and the defense will file a reply before February 20th, 2023. So we'll talk about that whenever that's filed. So that is the document to which that they got this article. So I can see both ends. You guys know I have to be fair. From a defense perspective, if, like I hear people say, if you're innocent, why don't you just give the information? That's the same logic, like people say, if you're innocent, why not talk to the police? Well, when you're in, I wouldn't talk to the police. If I knew, I was telling somebody today that if I knew that I wasn't even nowhere in the vicinity and somebody accused me of a crime and I was in Hawaii and got it on videotape and they say, well, talk to me and show me what you have, I probably would get a lawyer as well. Because they are very specific to tell you whatever you say can and will be used against you. So therefore, you have to be careful with what you divulge. Because even if you are innocent and you think, that's how most people get caught up. They're like, oh, I was there at 5 o'clock and then they got a video you someplace at 7 and you just were off by 2 hours. So it's always more, you should always be cautious and have an attorney. That's the first thing. If you plan, when it comes to a lot of this federal stuff, if you don't plan on pleading, it's kind of a catch-22. Because if you plan on pleading, then most people, if, say for instance, I'm the defense attorney and I say, okay, my client plans on pleading. If you tell me that you're not going to use nothing you find in these devices against my client by superseding the indictment with more counts, then perhaps we can talk about you getting into these devices. But we all know that the reason why you want to get into devices is because you either want to bolster your claim or you want to add more claims, right? So what people are kind of suggesting is that he should just give the government whatever. Like, why not give them the passwords? You know what I'm saying? So from a defense attorney perspective, when I did defense work, I probably would not be giving over no passwords and stuff either, depending on the situation, depending on the client, depending on what the client wants to do. But we all know, people were talking about how there are forensic experts that work for the government. We as defense attorneys have filed for forensics to look inside phones. Like recently, there were phones that I needed extracted. It's very, very, very expensive because then they have to translate the data. It's a lot to it. They don't just extract it. They have to translate the data and everything else in it. And they charge per hour and they charge a lot. But in addition to that, there's not software for everything like people think. So like, you have phones, like I've had experts tell me, depending on the phones, they can extract it, but there's some phones that they can't. Now for the government to say by the end of the quarter they should have the software, I don't know if they're trying to create the software, if they don't have it now, if they got to get it from someplace else. I thought that was an interesting response because there's certain software that they just have. You see, they were able to extract out the phones like immediately. They said that. They were like, we were able to extract out the phones. So I'm assuming maybe it's some software they don't have. And then also, I had a situation where somebody referred a client to me. It's been some years ago. And there was a young boy, he was probably like 15 at the most. You know, these younger generations, they've grown up with this technology. So he was able to create, he went on some black back page type of a site. And somehow he was able to just get credit cards and like it's just a list of credit cards and he was just ordering a bunch of Amazon. And he was really just doing it, not really thinking like, you know what I'm saying? Like, I'm a kid and I'm just doing this. But the interesting part was what he was doing, that sheriff's department, their forensic team was trying to crack those codes before. So they were more interested. You'll see sometimes the police are interested to know how you were able to do some of the stuff because they don't have, they don't know. So, but the feds, they're the feds. They're gonna figure it out. And it might just piss them off, like, you could have just gave us this passwords. Now we spent $1 quadrillion trying to get into this device. So thank you for the birthday wishes. Let me go to some of the chats. I agree that I have to agree with. You said don't get no. He has an actual defense attorney on his team as well. So I assume that she's dealt with this before. But the feds are going to get what they want, and not if there's more. My experience has been that if they have more charges they can against you, they will supersede your indictment and add more charges. They don't have no problem doing that. Eventually, I think they can, St. James, but there are certain devices that they don't have software for. Well, they may create some. I'm not saying that's the issue because I don't know what it is. Computers, iPads, it could be the handheld Kindles. Like I don't know. I don't even know what the devices are. They just said 13 devices. That's a lot of devices though. Harold Spell said they're going to throw the book. Well, I just wanted you guys to understand from the legal perspective. I know we all have, at this point, many people have their personal feelings, but it's still legal matters. And when you do legal matters, mm, would you really want your attorney just saying, yeah, just, it doesn't matter. Just, have willy nilly over all my stuff. And let me make it easier for you to come get me. I mean, what do you really? But again, sometimes though, when you have clients that plan on pleading, then their cooperation, you don't want to really piss off the AUSA. Like I've always had decent relationships with them, so I've never had these issues on dates and paperwork and them to death with emotions. Like I've just never had that type of an experience. So now let's go to the second. The second thing is on yesterday. That's why I was going to go live. The In the bankruptcy court, this is the glory of God. If you guys are not familiar with it, there was an article. Again, we read articles, but usually over here we try to have court documents with the articles because we want to see it for ourselves. Just like how we seen this whole article on the federal website on what actually took place, and it's a little different than what was reported. So we try to make sure that what the accurate pleading says, that we talk about it over here. So yesterday, so we know that the trustee Whitehead, who said he's the trustee over 5904 Foster Avenue, which is the church building, he said he's the trustee of that trust where the building is in the trust. They've been in a show cause hearing for the last 2 days. We didn't really see much except for the filing of who the alleged settlor and the trustee was, according to the documents. Assuming the judge may render an order and do an opinion or something at some later date. But in the interim, apparently there was enough information that was established for the glory of God's attorney, which I heard was the great, great attorney. And she filed a motion to dismiss. And let's look at why she filed this motion to dismiss, guys. And there's some other stuff that I noticed about this whole thing that I thought was a bit suspect. Let me see. So as you see on February 3rd, a motion to dismiss was filed. And let's go to the background. So it says on January 24th, 2023, debtor, which would be the trustee Lamore Whitehead, commenced the above caption case under Chapter 11 of the Bankruptcy Code. Debtor 5904 Foster Avenue Trust is a trust instrument created pursuant to an agreement between Lydia Moses, who is a settler, and Michael Moses, who is the trustee. And it was January 27, 2022. And they'll be identified in this document as Foster Avenue Trust Instrument. Paragraph 4, the Foster Avenue Trust Instrument is a writing declaration and agreement regarding the creation of the trust, addition of settler property to the trust, the beneficiaries of the trust, and regulations and allocation of the settler's property to the heir and beneficiaries of the trust. Debtor's bare bone petition, which lists Glory of God as a creditor, is in violation and abuse of the Bankruptcy Code as it is not an eligible debtor. So they're saying that the creditor, the creditor, which is Gloria God, listed as a creditor, that the petitioner is not an eligible debtor. And the reasoning is the debtor is not a business trust. So Chapter 11 is filing to reorganize your business. After they were able to look in the trust is more like a family type of a trust. Remember, we talked about how trusts have education. It may have different dates for you to give out money. What happens when you're sick, spendthrift clause. It has things that it seems like it has the provision on minors. It has all these different provisions in it, which let you know it wasn't like for business. Like some people that do fixer uppers and they flip property, they put it all in trust, or they have their rental properties in a trust, but they have 5, 6, they're consistently adding to it. So it's more like a business. So they go through the law, and in paragraph 6, it says numerous district, bankruptcy, and circuit courts have held that a trust established for family or estate planning purpose is not a quote business trust within the Bankruptcy Code. Definition of corporation, meaning the trust is not a person. Under 11 USCA section 109, eligible for bankruptcy relief. This is based on a finding that the trust does not engage in business or commercial activity or does not have sufficient attributes of a corporation. The Second Circuit held that a trust does not qualify as a business trust for bankruptcy purposes merely because it generates profits, but rather this inquiry must consider the totality of the circumstances and whether the trust was established to transact business. In Ray Security Equipment Trust of Eastern Airlines, Inc., 38 Federal 3rd, 8626, bankruptcy, CRR, Y'all see all of the sites. These are where you can find the whole case if you guys are that interested. The court noted that in basic terms, quote, the distinction between a business trust and other trusts is that business trusts are created for the purpose of carrying on some kind of business, whereas the purpose of a non-business trust is to protect and preserve rest, end quote. Id at 90. Although the trust hired accountants, attorneys, and marketing personnel to conduct leasing and selling of property, the court found that its true purpose was to secure repayment of certificate holders' loans to the trust and thus was not a business trust. It at 92. The Third Circuit has held that the trust was not a business trust and was therefore ineligible as a debtor for Chapter 11 bankruptcy purposes because the trust was primarily for the benefit of a settler and her family. That's N. Ray Eagle Trust, 1998 Westlaw 635845. Blah, blah, blah. Although a debtor received income from the real estate and personal property he owned, the court noted that by the debtor's own admission, the purpose of the trust was to preserve and protect the family's assets. It at 3. The court also noted that rather than being formed by a group of investors contributing to capital for the purpose of earning profits, the trust was created by one person who transferred assets to the trust for the purpose of estate planning and asset protection. The court further noted that the trust was not freely transferable and was therefore not a business trust. In Ray Woodville Realty Trust, the First Circuit noted that, quote, generally trusts are not eligible for relief in the bankruptcy court, end quote, unless they are, quote, business trusts. end quote, with corporate attributes. In that case, the court provided a non-exhaustive list of factors which identified a trust as a non-business, including the beneficiary controlling the trustee, the beneficial interest not being transferable, a fixed termination date, and a lack of any outside investors. Also, in another case where the sole asset of a real estate trust was a strip mall shopping center and the trust had no employees and few unsecured creditors, the First Circuit likewise dismissed the debtor's trust bankruptcy petition because the trust did not qualify as a business trust under state law. In that case, the court also noted that such situations where a non-business trust files for bankruptcy may raise issues of bad faith and abuse of bankruptcy proceedings in consideration of whether a trust and beneficiaries have sufficient assets to fund a plan of reorganization and pay unsecured creditors. Paragraph 10, in distinguishing between a business and an estate planning or family trust, the Second Circuit's position is that this inquiry focuses on the trust documents and the totality of the circumstances, in conjunction with factors that other district courts have deemed indicative of family and estate planning trust and not business trust. Various aspects of the Foster Avenue Trust instrument indicate that it is not created for business purposes. So now they're going over applying the law to the facts of this case. The Foster Avenue Trust instrument makes numerous references to the trustee's ability to use income generated from the trust for the quote educational, reasonable support and comfort, maintenance or health of the settler's spouse and the spouse's siblings and their children and grandchildren. Although the instrument does not explicitly state that the primary purpose of the trust is for family, estate, and asset preservation, the court in In re Delay noted where the instrument unequivocally stated that its purpose was to provide for the settler's family. That is a family trust, which is not eligible for bankruptcy. Let's move forward. Article 8. So then they go through the whole trust. See, remember when we started and I told you I don't do bankruptcy, but it seems like to know who the trustee is and what's even in the trust seems more important to look into before you can even we could really move forward in this. And apparently during that show cause, because that guy Michael Moses was listed as a creditor, his attorney showed up to that show cause. So I'm assuming they showed up with the actual trust agreement, and that's where it came from. Article 8 of the Foster Avenue Trust Instrument contains provisions for power and trust for minors. Article 10 contains provisions accounting for the simultaneous death of the beneficiaries and settler. Then you have Article 16 empowers the trustee to manage life insurance policies on behalf of the beneficiary. These provisions indicate that the trust purpose is to provide for the settlor's family. The court also noted in re Delay that where the instrument created a provision where the trust would terminate within 21 years of the death of the settlers, the last survivor, or living issue. Such a provision indicated that it was not for a business trust. The Foster Avenue Trust instrument contains an almost identical provision. Furthermore, the court in re Delay found that where the instrument empowered the trustee to take control of the property upon the death of the settler, the trust does not qualify as a business trust. And they say they have an article here again that contains a similar provision. Next, the Foster Avenue Trust instrument contains a spendthrift clause, which prohibits the beneficiary from transferring interest in the trust. As the court noted in re Quadruple D Trust, a spendthrift clause in a trust agreement is powerful evidence that the trust does not have a business purpose. In re Quadruple D Trust, and this is a 2022 case. The court also noted in re Quadruple D Trust that because the instrument did not did not identify any ownership interest possessed by the beneficiaries or otherwise indicate that the beneficiaries were required to contribute to or invest in the trust, this was a restriction on transferability. The court noted, quote, every case that has involved a restriction on the transferability of the beneficiary's interest, whether a nominee trust or not, has held the trust did not qualify as a bankruptcy debtor. Here, Foster Avenue Trust contains no provision whatsoever which identifies the interest of a beneficiary or obligates contributions or investments to the trust. These are key features which distinguish business and estate planning family trust, and it would be highly unusual for a business trust instrument to be entirely void of provisions addressing the rights of a beneficiary. The fact is, debtor is not an eligible debtor under Chapter 11, and his petition should be dismissed. As stated in Glory of God's prior application to dismiss or lift the automatic stay, this Chapter 11 filing was made solely for the purpose of avoiding the state court order restoring possession of 5904 to 5912 Foster Avenue, Brooklyn, New York, to Glory of God, and is in bad faith. Based on the foregoing, it is respectfully requested that the court enter an order dismissing the debtor's petition with prejudice. So Maceo asked, so is Michael Moses on the side of Glory of God? So you guys ready for some of this? Now I hope the white van don't come find me. I'm in another state though, so y'all can't find me right now. So I was trying to look up to see who owned who, which way, and how. So I kind of started from the beginning. You said, can I summarize this for all of y'all in the back? Okay. So in summary, Glory of God's attorney has filed a motion to dismiss this bankruptcy petition. And their reasoning is because after looking into the actual trust document, it's a family trust. It's like an estate trust for your family when to give income every month, to provide education. It's for that purpose. It's not a business trust. He filed this as a Chapter 11 reorganization of a business. Hopefully that helps. So let's hold on 1 second. Let me move my thing over. So we're gonna try to go through this, and I hope it isn't too hard. So let's go to the invalid deed. So remember, we discussed in the last video that Triple C Venture is the owner of this property. Fund Me Williams is supposed to be the president of Triple C. Glory of God basically, I guess, leases, rents, occupies the property, and the pastor is the Williams. So that's how it originated. Apparently, Triple C took out 2 mortgages. When they took out 2 mortgages, a deed was placed in a trust. The trust was called the YYSB Trust. That's what you're looking at right now. Allegedly, they defaulted on the loan. And what YYSB did, according to Triple C, is instead of notifying them of their default and starting a foreclosure process, they just did a deed in lieu of foreclosure. So I'm assuming it's going to be something about some signatures and all of that, unless they had pre-written it and already had it ready, just in case. I don't know. But they're saying that instead of giving them notice and going through the proper foreclosure protocol, YYSB just signed and did a deed in lieu of foreclosure, and now they own this property at 5904 Foster. As you guys see, Raphael Grossman is the trustee for YYSB. Okay, according to this. Now, there's another Grossman whose name was in the documents. I think it's Israel Grossman, but it's a bunch of Grossmans, right? Because I was looking at something else. Let me see. We're gonna go through this together. Let me see. Yes, Jessica Grossman, right? See, I think she was looking too. So if you look at Acres, you have the Grossman. This is the deed lookup search for New York. The Grossman Family Trust, they own 1078 East 15th Street, trust, right? And that trust owns a property at 1078 East 15th Street. So I want y'all to remember that. So though that's the Grossman Trust. If you guys look, wait a minute, I might have stopped sharing too quick. Michael Moses is the trustee for 1078 East 15th Street. Y'all see that, right? See, they put on there who the trustees are. When it comes to the 509, 505, whatever, y'all know the address by now. Over there on Foster Street, there what the trustee wasn't listed on the acreage site. But here it tells you. So the Grossman Family Trust, they transferred that, and then it's in the 15th Street Trust, and Moses is the trustee. So you guys keep in your mind 1078 East 15th Street. If you look at here, now at the foreclosure sale, this is a tax foreclosure. Remember, all this stuff happened because YSB allegedly didn't pay taxes. There was a foreclosure sale in January. The 509, you guys know the address. Over there, 5904 Foster, where the trust bought the property in a tax sale. When you look at 5904 Avenue Trust, the address right there connected to it is the 1078 East 15th Foster. So the YSB, whatever their names is, that YYSB that took the property in the first place, they're somehow connected to Moses because he's been a trustee on their properties before. But then the address for the 5904 Foster Avenue is the address used for them is something where Moses is the trustee of. I just was like, so it seems to me, based on this, the gross, and I don't know. So Gloria Gadge, y'all attorney, I'm sure she owned it and she looking into it. But it seems like the same people almost repurchased the property in the tax sale. That's what it looked like. Like there's some connection to that. Now I don't know who Moses is. Maybe he's just somebody that just does a lot of trustee work because some people do that. So that could be an option as well. But it's the same names that you're gonna see. You're gonna see Moses and you're gonna see Grossman on all the properties that's connected in this thing. So the Hasidics run real estate in New York County boroughs. Okay. This allegedly. No, but I was trying to follow the trail on who, because why we were confused, I think in the first place, was because when you look online, I literally couldn't tell like who. So maybe Whitehead was added as because I'm still trying to figure out how he's even connected to this. So maybe somehow he became an added trustee or something, because the site literally does not name who the trustee. If you look on the 5904 Foster Avenue, let me see if I can type that. Let me share my screen. So this is the Foster Avenue. You see how we looked at the other one and it showed who the actual trustee was? Like this one doesn't show who the trustee is on there. It just I mean, it just has the name and that's it. And it doesn't have the name of the trustee. That's what was confusing me. Because I was like, okay, most of the time you look it up, and if it's in a trust, it'll have in parentheses who the trustee is. This document didn't have that. So maybe perhaps when we looked at the prior case, when we were looking at the landlord tenant case, and remember the pastor said this guy just kept calling me and he didn't really give proof that he was the actual, bought the property or that he had any connection to the property, and they didn't know whether he had a connection. Maybe that's why, because the name wasn't on here at that time. You guys are lit. I So Jessica says, so Grossman did the thing with the deed initially with the intent of passing along to another trust in their own interest. I don't know, but all these the address for the foster. So Moses is the trustee for the 5904 foster, which is where the church was having service at and was kicked out, illegally evicted according to the court. The address that is used to contact 5904, that house is in trust. And according to that document, Moses is the trustee for that house as well. And then when you look at the YYSB, which originally took the deed in the first place, it looks like the Grossmans, who originally gave Moses as the trustee to all these properties, were the initial trustees on the property for YYSB. That's why I said these same names keep coming up on all these properties. You said this is a hot mangled entanglement. Yes. So yeah, that's it, y'all. And then one more thing. Let me see. Friday. Oh, I can't find it. I was gonna try to find because I don't have my phone. It was something I was gonna play for you guys, but I'll play it tomorrow. So yeah. So you guys, my birthday's in 15 minutes. I have to reiterate that. So tomorrow we'll come back on and have a little chit chat and just kick it. So Maceo asked, so there was a question, is Ponder still listed on the case as his attorney? I read a comment earlier that he wasn't. So there was a comment, and I'll try to go back in my comments. What happened is, we all know, we saw the initial petition where when Whitehead filed, he filed himself. So I think that's why they thought he was pro se. So initially he filed it himself, and then as we saw as it progressed and it turned into a hearing and a show cause, and people were fighting against his petition, then his attorney came in, entered an appearance as a representative of the trustee and the trust. So I believe that he is still, I don't see anything otherwise that he's not still representing him. Yes, my birthday's in 15 minutes. CBBJ says, so there's no amended trust anywhere. He's just verbally saying it. He's a trustee. I don't see. I wasn't there, but I think their attorney probably brought that up. There being Gloria God's attorney brought that up maybe at the show cause hearing. We just don't have any type of order on what the conclusion of that hearing was. But clearly they decided, you know what? Let's file a motion anyway. So, and then I tried to look back at the landlord tenant case and I didn't see any new activity either. So we really don't have anything until they file it for us to see. That's why he wants 20 million. He sued he sued LRL for 20 million back in September. He sued Jives back in September, and then he sued a couple of months later. He sued the DJ Miss Jones in New York for $50 million. So Miss Jones' case, their first response to his complaint was to try to dismiss it and say, essentially, we went through that. So if you guys are unfamiliar, because I know it's a lot of new subscribers, and welcome, 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 welcome. As you see, we do things a little bit different. I pull up the paperwork so you guys can see exactly what's filed. And if anybody has questions about the paperwork, we go through it, because although I love a lot of the articles that come out, and I try my best not to be biased. I think we don't have to like add and exaggerate. We can really just look to see how shady some of the stuff is. We don't really have to look at the papers. And it's just getting more. I think the what did the headline say? The bling Mayor Adams bling bling friends won't give over 13 divide. I'm like, come on now. Like, so now they're making it very, very clear to me that the only reason why that they're reporting this is separate from why we talk about it. We talk about it because we started out like, people were telling me about different situations they were in, lawsuits that were filed, and how they wanted their money back if they felt like they were owed. So we started navigating and going through paperwork and making sure we had the right information. They seem like they're doing it more for political reasons. They like, you don't really care about these people that this stuff is allegedly happening to. You're just trying to, you guys just hate Mayor Adams. And that's all I've learned from this. I'm like, oh, you guys can't stand him, huh? And then a lot of people in the chat were like, yeah, nobody really likes him. So it became very clear that that was the real motive. So Monica says, so you know how people have shell companies. Is this Moses person a shell or cover for Whitehead? I don't know. I don't know who the person is. They give like a Maryland address, but I don't know who the person is. But it has to be a person because they had their own attorney. And then he listed them as a creditor. So they were considered separate from him. Maceo said, yep, they just trying to highlight his link to Adams. That's starting to become very, very clear, because even though I know that he believes he's so popular and he's famous and all of that, you're really not. So yeah, we're talking about you, but that's just like I talk about local people in my area that people never heard of. It's literally they're linking you to Adams, and I don't know what the political climate is there now. If they're trying to raise someone up to take his position, I don't know what it is, but it's really starting to be evident that a lot of it is just political. They're a creditor because that's who helped them gather the funds to purchase that church in a tax auction. That may be true. That's an interesting, but see, I think they have a creditors hearing that is set for later on this month. And so all the creditors come to that. So I guess, well, Gloria Guy was saying they not a creditor. They just trying to get access to the building. That's it. That's all they want to say. Thank you. Thank you for the happy birthdays. I appreciate it. He says, as long as all their victims get their day in court with Whitehead, I'm not mad. That's it. You know what I'm saying? Like, I think you turn people off where you, like, some people might say, well, maybe he isn't this, maybe he isn't that bad the way people are portraying him. It's just a political, political stunt. And it's really starting to look political. Like, everything they can say, like, for instance, it was an article that came out earlier. Another one, I guess, of Mayor Adams' friends was indicted for something, and they had a headline that was the same. It was like Mayor Adams' a friend of Mayor Adams was just indicted for da 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 da. So that's starting to be the headlines that they're using. So it's more not that you're somebody to focus on, like I think he wants to believe. It's just that your connection to him and they want him that bad. But that doesn't negate the fact that there's some things that you're doing that allegedly seems like, if it's true, that what people are saying, alleging about you, that doesn't mean that that's okay. It's just that the publicity that's out there is because of the political connection that you have. Thank you. You said the restaurant owners got in something last week and they brought up Adams. What restaurant owners? Yes. Please, guys, like, share, and subscribe if you haven't done so already. If you guys are enjoying the content and our breakdowns, please subscribe to our channel. We do it a little bit different over here. We take our time and we try to learn it from the legal aspect. So hit the replay, listen to some of the previous video if you don't understand what's going on. I think the first video we were kind of learning it at the same time because I didn't know anything about what was going on with this building, this church, this bankruptcy. They were in landlord-tenant court. There was a foreclosure sale. It's three different cases pertaining to this building because you have the tax foreclosure that started all of this. You have landlord-tenant, and now you have bankruptcy court. And then he has the federal court because the federal criminal because of his indictment. And then we still are keeping our eye on the robbery. We have the dismissal for Miss Jones. That's probably not even going to be her because they're so behind in New York. The dismissal for Miss Jones is later on. We have Miss Anderson. Her case, they're waiting because he was challenging whether he was properly served and jurisdiction. So they have like some type of hearing going on to whether it was proper service and jurisdiction. Then we have the Connecticut case, which is the properties he owns in Connecticut and how they got a default on the business for the property that holds the property, the company, and they're trying to fight that. So there are several cases that are going on right now. Dang, Maceo, you done already got him. You done already got him convicted, right? He said, "Do you think his resistance to cooperate with the feds will backfire during sentencing if he is found guilty?" Found guilty meaning by a jury, or if he pleads, because there is a difference. They'll say that they don't differentiate between you pleading and you going before a jury, but there's a difference. There is when you admit fault. So you have sentencing guidelines and you have points. So they allocate points towards which range you end up when it comes to whether you can have probation or you get a bunch of years in prison, like the top of the guidelines, the bottom, and then you file sentencing memos because you basically try to minimize so your client would be at the lower end of the guidelines. One of those things is cooperation, whether they cooperated. So, but that's usually with plea deals that it matters. Oh my goodness, guys. Do you think that Whitehead went to Trump for business advice that he's losing so much? Trump, it's a New York thing. I was just talking to somebody. New York has some very creative people that if they used it on the right side of the law, they'd be trillionaires. Because some of the stuff they come up with is like, whoa. And you said he better not get away with any of it at all. Yeah, it's tricky when it comes to like sentencing, Maceo. Like the fact that you have a record, that's against you. But somebody who doesn't have a record, that goes for them. There's so many different criterias when you go through the sentencing guideline on how someone is sentenced. And then of course, um, we, as you know, well, the defense side, we're trying to get it as low as possible. We always gonna ask for probation. You don't want to see your client get hauled off to prison. So you always gonna try to get some type of probation for your client. But the government, a lot of times they try to tell you not only should they not get probation, we should go, there's substantial and compelling reasons why we should go above the guidelines, and they should get even more than what's in the guidelines. So they may come to some type of compelling reasons why it's so egregious that they should go above and beyond. So that's why I said it's not good to even try to tee them off, because you want, sometimes you can, they'll say he was cooperative, she was cooperative. You know, every now and then you'll get a memo where they kind of help you out just a tad bit. But for the most part, you're on opposite ends. You're trying to get your client at the bottom of the guidelines, and they're trying to get them at the top. So yeah, I think he's trying to set a world record for the most lawsuits. You think? You said you're flying out there. Me too. If he goes to trial, how many people think he's going to go to trial though? I'm not sure if he goes to trial on this. Like, say if they come to him and say, if you plead, then we'll give you probation and you won't get, we can guarantee you not having jail. Well, I don't think they can do that because he got a past record. Let me scratch that. Scratch that whole. Or they offer him a plea where, okay, you only gonna do 18 months if you plea, as opposed to facing the astronomical amount of years that they said he could be facing. On the he can only go to jail on on one case. You said on which case? Daniel said he 10 toes down. All right. You know what? So you don't think he'll go to Janika? I hope I'm saying your name right. Thompson, I don't think he'll go to trial. You said he'll make it into the courthouse in cuffs. That's what Patrice mom said. Remember, 10 toes down, 10 toes down, 10 toes down. You said he cannot afford to go to trial. This is his third strike. Is it his third strike? Wait a minute. He got two cases. Nope. He had two cases in New York, and he had one in New Jersey that he pled guilty. He pled guilty to one in New Jersey. I believe he had two cases in New York that are separate from the one he went to prison from. And then the first case he had was like in New Mexico when he was in college or something, but they dismissed it once he paid restitution. It was like a forgery type of the case, and they dismissed it once he paid restitution. So I think he's at past his three strikes. He said he's not going to take a plea. His pride won't let him plea out. Yeah, I think he's going to go to trial. But we'll see, guys. We'll see. Oh, it's my birthday. Thank you, guys. Thank you, guys. Thank you so much. I wanted to stay on here and say, spend my first few minutes of my next age with you guys. Thank you guys for coming on. I know it's late. He has too much pride. Yep. Thank you, CBBJ. I appreciate it. That's why he's filing all these motions. He's trying to confuse them. Well, the AUSA does this. See, when you do civil cases, oftentimes you file a lot of paperwork. We file motions on each other. We do discovery. We do paperwork each other to death, and it's kind of like a game. But you don't really do that in criminal. You know what I'm saying? Like, typically they just turn over what you're supposed to have. You call them like, hey, that discovery is late. You ain't give it to me. We got an exam next week or whatever, and they give it to you. Usually don't even go through all that in criminal. So they're probably not used to someone filing the way that they're filing. But thank you. Thank you. Yes, you guys. Any plans for my birthday? Well, I'm actually out of town now, so we'll see. We'll see what the plans are, but I am gonna come back tomorrow evening and celebrate with you guys for a few minutes. Thank you so much for the super chat. I appreciate it. Thank you, Daniel. I appreciate it. Go, 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 go. I don't even have my cell phone. I left it in the car and everybody's gone. But I know like my mom always calls and sings happy birthday. So I don't even have my phone right now. Yeah, I'm coming back today. I said tomorrow. I'm sorry. You know. All right, y'all. Well, so we covered it. We covered everything. I was gonna play a couple of videos, but they're on my phone and I don't have it because I didn't want to like put it in the video because I'm not trying to get it struck. So I was just gonna play it for you guys to hear. And maybe I can do it. Let me see if I could do it right quick. And just don't share it on here, perhaps. Hold on one second. See if I can find it. Okay, here it go, y'all. Can y'all hear it? Wait a minute. Can you guys hear it? You guys can't hear it? Okay, hold on one second. Okay, let me see.
Wanted to be on the show. I said that's not a good idea because I up for some other fights you gotta have. That's so funny.
That's so great.
You're going to jail, ain't it? You need to be warming up for some other fights you gotta have. That's so funny to me. This is what happened. He called my Skip Cheeto, my executive producer. They wanted to be on the show. I said that's not a good idea because I think you are a charlatan, or told his people. No, it's gonna be cool. And sure enough, what happened? We had this argument. He got mad. I want to fight you. All right. Well, he said we're gonna have a celebrity boxing match. I'm like, who's the other celebrity? Like, what? Like, well, you famous for getting robbed on TV? That's not a TV show. That's not a TV show. And now what is he indicted for something, right?
Yeah, I think so. Yeah,
I would say it's interesting to how black women are really, in terms of on the legal front, they like in Atlanta, in Michigan, and with some black women put in jail.
Yeah, they're not playing. The DA in Atlanta not playing.
Man, Young Thug and Gun. If your name is
Sorry, guys. Yeah, they talked about it on the Breakfast Club. I was trying not to like embed it in my video, but it was only a few seconds. But I thought it was interesting that they talked about him on Friday. And basically, as you see, DJ Envy tried to be funny, like he was trying to work out to do the celebrity boxing match with Whitehead. And basically, DL was like, well, who the other celebrity? So anyway, y'all, thank you so for joining me. We'll catch up with each other later. I love each and every one of you. Thank you for all of the birthday wishes and the super chats and the cash apps and all of that. I love you. I love you. I love you. And I will catch back up with you guys tomorrow. It'll be in the evening though. It won't be during the day or early on. Thank you so much for all the birthday love. Hugs, hugs, hugs.